So, first of all, I wish to thank the organizers for giving me this great opportunity to be here today and addressing this very qualified audience on maritime affairs. You can read on the slide directly the agenda, and I hope it will be quite interesting. So let's start with the very well-known theory of the British academic Ken Booth, under which the functions of navies in peacetime are diplomatic, military, and policing. Apart from their main military task during armed conflicts, navies can be qualified as an instrument of foreign policy, since they are able to play a flexible role widely representing their country all over the world on preserving peace and security on the oceans in peacekeeping operations carried out under the authority of UN Security Council, such as the naval embargoes. But navies also have the power, in accordance with international law, as reflected in United Nations Convention on the Law of the Sea, to maintain freedom of navigation in the sea lanes of communication for benefits of maritime trade of all nations. Freedom of navigation on the high seas is a vital prerequisite in enabling the navies to play these international functions. This is no doubt, in fact, that naval forces need to freely move in the maritime arena in order to maintain their autonomy. The long-standing principle of sovereign immunity recognized by customary international law to warships is strictly related to this essential autonomy. During the past centuries, the high seas were the place where navies carried out their activities in peacetime on the basis of principle of equality between all nations. The respect of this principle implied that warships could not interfere on the high seas with the free navigation of other flag merchant vessels unless in the cases of piracy, slave trade, or lack of nationality. Even today, this legal regime is still in force since it is considered as part of customary international law as reflected in UNCLOS, the previous law. The problem is that the extension of the high seas has been gradually reduced due to the enlargement of the territorial waters from 3 to 12 miles on the basis of various reasons such as security, strategic, and military ones. Nevertheless, the innocent passage regime allows warships to transit through both the foreign territorial waters and specific category of straits. Furthermore, the passage regime in the major international straits like Gibraltar, Hormuz, and Bab el-Mandeb ensures navies free passage across shipping routes that are vital for the flow of international trade. Another limitation to the extent of the high seas arose from the creation some decades ago of the economics exclusive zone, extending to a distance up to 200 miles from the baseline. This space, formerly high seas and now qualified by UNCLOS as an international waters, is subject to a regime in which the coastal state exerts sovereign rights over natural resources and the related jurisdiction, but may not claim or exert sovereignty. But let me remind you that the merit of having preserved over the years the mobility of naval forces belong to United States by means of their freedom of navigation program, aimed at exercising and asserting the rights of the third countries in foreign economic exclusive zones, as well as the contiguous zone and in the international straits. After these preliminary considerations, addressing freedom of navigation and the challenges this principle has to face, nowadays, let us now focus our attention on security at sea. Nowadays, there are two major well-known threats to the security of navigation: piracy and terrorism at sea. Piracy and maritime terrorism are terms used to describe violent acts carried out by malevolent actors operating at sea. Previously, we typically correlate the phenomenon with acts of war committed by rogue ideologues, while now it connotes criminal activities committed by brigands for profit. Both threats see the navies engaged in their contrast. In recent years, maritime piracy has re-emerged as a serious threat to peace and security, notably following the significant increase in incidents at sea that occurred off the coast of Somalia and in Gulf of Guinea. International cooperation is indispensable for combating piracy. The duty to cooperate in the repression of piracy exists under international law. This duty, as articulated in an article of United Nations Convention of the Law of Seas, should serve as a guiding principle in identifying the specific obligation imposed on the states. It is further submitted that successful undertakings to fight maritime piracy necessitate interdisciplinary cooperation, namely cooperation among entities whose expertise generally lie in different fields. Indeed, international instruments repeatedly refer to the importance of international cooperation in the repression of maritime piracy. Thus, for example, the United Nations Security Council, in its series of resolutions related to the threats of piracy and armed robbery at sea off the coast of Somalia, and more recently also in the Gulf of Guinea, urged all states to cooperate each other and with international organizations in combating acts of piracy and armed robbery at sea. The importance of international and regional cooperation in this domain was also highlighted by the United Nations General Assembly in its resolution on oceans and the law of the sea. Notably, the first mentioned article of UNCLOS, titled Duty to Cooperate in the Repression of Piracy, specifies that all states shall cooperate to the fullest possible extent in the repression of piracy on the high seas or in any other place outside the jurisdiction of any state. The duty to cooperate is at the core of the piracy section of UNCLOS. Indeed, it is the first provision of this section, thereby providing the appropriate benchmark as well as framework for the substantial provisions that follow. Since piracy takes place on the high seas, and often very far from the shore, combating piracy acts requires more than the typical police prosecution cooperation, which is predominant in the land-based ordinary law crimes, such as theft or robbery. Notably, it calls for the involvement of navies as the frontline entities that both prevent attacks and gather relevant information that can facilitate prosecution. In fact, in such operations, the navies exert activities of law enforcement nature. Both navies and shipping industries have been working to devise deterrence measures against piracy, in particular off of the Somali coast. However, many experts stress that most of the current tactics do not reduce the instability inside the state, which is what allows piracy to flourish. Following the 2008 UN resolutions, 3 main naval missions have been deployed to Gulf of Aden, namely NATO, EU, and combined maritime force operations. There are also independent Navy ships, including those of Australia, China, India, and Russia, patrolling the corridor from all over the world. Maritime piracy has posed considerable risks to the international community. As already stressed, a key component for the successful counter-piracy undertakings in the international cooperation among states, international and regional organizations, and the private sectors. Sharing information is one of the specific duties within the general duty to cooperate. Therefore, it should lead to regular exchange of relevant data among all actors involved. Restrictions based on national security and classification rules ought to be applied only on exceptional basis. And now, going to the maritime terrorism. In general, this expression means terrorism at sea. However, the security implications of maritime terrorism are many. First, maritime terrorism involves terror attacks directed against assets in the maritime domain. These include attacks of threats or threats of attacks against vessels, harbor anchorage attacks, fixed land-based targets near ports, oil refineries, oil storage depots, other port infrastructure, energy pipeline and undersea cables, and hijacking of commercial or passenger ships on high seas. This also includes putting obstructions such as sinking a large ship in choking points in critical sea lanes of communication, for example, Strait of Malacca and Hormuz Strait, to disrupt global trade and commerce. Second, maritime terrorism denotes terrorist attacks using maritime assets as platform to deliver attacks against either land-based targets or targets at sea or both. The October 2000 attack on the USS Cole in the port of Aden in Yemen was delivered by a fast speedboat loaded with explosives and was the MV Limburg case in October 2002. Terrorists used a maritime route and a cargo ship and the rubberist dinghy to land on the Mumbai coast to carry out spectacular attacks in the city in November 2008. This also includes hijacking a commercial vessel or a cruise liner and using it as a floating bomb to ram against a maritime target to cause widespread death and destruction. Third, maritime terrorism also involves use of assets by the terrorists for purely logistical purposes, such as sending members from one country for training and/or asylum in another country. Terrorist groups have also used boats and other maritime assets to carry out piracy for financial gains. International treaty law, as well as the customary international law, have developed mechanisms to suppress acts of violence at sea, such as piracy or other acts directed against ships, airplanes, or platforms. However, new developments seem to indicate that these mechanisms do not embrace modern threats. In particular, these mechanisms have not explicitly provided for measures taken in response to ships being used as weapons. Important amendments to the 1988 Convention and its related protocol were adopted by the Diplomatic Conference and the revision of the Suppression of Unlawful Acts Treaties held in London since October 2005. The amendments were adopted in the form of protocols to the CUA treaties. The 2005 protocol is one of those recent legal instruments which may provide the basis for limiting the freedom of navigation. The protocol introduced a new article concerning the procedures to be followed if a state party decides to board a ship flying the flag of another state party outside the territorial sea of any state, when the requesting party has reasonable grounds to suspect that the ship or a person on board is, has been, or is about to be involved in the commission of an offense sanctioned by the Convention. The authorization and cooperation of the flag state is required before such boarding can take place. Such authorization may be made in general or given on an ad hoc basis. And this brings us to another initiative worth mentioning. The multilateral mandate measures against the maritime transport of weapons of mass destruction are being supplemented by measures having a bilateral basis, named the Proliferation Security Initiative. The objective of the PSI is to interdict the transfer or transport of weapons of mass destruction, their delivery system and related materials, and from states and non-state actors. Intercepting ships suspected of carrying weapons of mass destruction without the consent of the flag state raises the question of the compatibility of such actions with the law of sea, at least as a matter of principle. Under the Convention, the competence to intercept a vessel depends on where such action is undertaken, in internal water or territorial sea of a state, in the exclusive economic zone of high seas. So this concludes my short speech, hoping it was interesting, and of course I will leave my speech to my friend Boaz Ganot so he can, spread probably something. Thank you so much for your attention.